Chapter, and on behalf of Judge Arnold Golden and Judge Carmen McGee, I welcome you to this oral argument this afternoon. We're going to conduct the argument in much the same way as if we were all in the courtroom together in person. Mr. Knight, I believe you represent the appellate, and you have requested 5 minutes of rebuttal of your 15 minutes to be used as rebuttal time. That request is granted, and the timer will be set accordingly before you begin. If there are no preliminary matters, I will ask Ms. Lindsay to call the case. Ms. Lindsay.
Old Hickory Coaches, LLC versus Star Coach Rentals Incorporated et al.
Thank you. May it please the court, I'm Stephen Knight representing Old Hickory Coaches. Old Hickory's appeal raises two issues. The first one is whether James Copeland is a defendant in this case. The second issue is whether Mr. Copeland admitted in his answer and counterclaim that he was a party to the contract that's at issue in this case. Both of these issues can be decided by reviewing the complaint and the answer and counterclaim. Might be helpful also to look at the summonses that were issued and served in the case. And I think the court will conclude it's very clear that the answer to both questions is yes, Mr. Copeland is an individual defendant and he did admit to being a party to the contract. In fact, he filed a counterclaim that the court determined the gravamen of which was breach of the contract that he now is disavowing. So on the first issue, whether he's a defendant, the rule is, and this is no surprise to anyone, that the identity of the defendant is determined by the allegations in the complaint. So this complaint, from start to finish, the caption identifies Star Coach and James Copeland as defendants. The preamble identifies Star Coach and Copeland as defendants. In the parties section of the complaint, Mr. Copeland has his own paragraph. He's identified as a defendant. In the causes of action section, it's alleged that Mr. Copeland is liable for a breach of contract. In the prayer for relief, the plaintiff asks for judgment against Star Coach and Mr. Copeland. So there's really no ambiguity in the complaint about whether Mr. Copeland is a defendant. In addition, some of the cases indicate that when there's some question about whether a certain party is properly included in the case as a defendant, sometimes the courts will look at the summonses to provide notice, fair notice that someone is a defendant in the case. In this case, there were two summonses issued, 2 copies of the complaint served, one on Star Coaches and one on Mr. Copeland. The defense to this and what the trial court found in response to our motion to amend after trial and after the court's memorandum and order is that Mr. Copeland was sued only in a representative capacity as president of the corporation Star Coach Rentals. There's nothing like that in the complaint. The complaint doesn't even mention that he's the president. But even on top of that, that really doesn't make any sense. There's no reason to sue an executive as representative for a corporation. Corporations can be sued directly. There's a specific statute in Tennessee and in New York allowing that. I'm sure in every state there's a statute.
But it would make sense to sue Mr. Copeland individually, would it not, if there was some tort alleged against him?
Well, sure, there could be, but also he could be a party to the contract. It's not unheard of. It's similar to a guarantee for a loan, especially with a mom and pop business. We cited the court to a case involving music promotion where a part owner of a company signed with a marketing firm, signed a contract, and there was some question about whether he, in addition to the promotion company, was a party to the contract. And it was held that he was. All the services were provided to the company, his only connection was that he was a part owner of the company. But of course, he was also a party to the contract. That's what's alleged in the complaint, and it's admitted. That, of course, is the second issue. If you look at probably the strongest examples are paragraphs 18 and 19 of the complaint and the answer and counterclaim. Paragraph 18 alleges that the first agreement was a valid and enforceable contract between Old Hickory, Copeland, and Star Coach. And the response is defendants, plural, admit that the parties orally and initially agreed to split the rental income. And again, in the next paragraph, the allegation is that the first agreement provides that Copeland and Star Coach must give 50% of the rental income to Old Hickory. And the response is defendants admit that the parties, again, plural, defendants and parties, there's only two defendants, so there's no question about who that is, admit that the parties agreed to split the rental income. So, of course, an admission in a pleading is binding. It takes the issue off the table. There's no need to present any proof on it. And Mr. Copeland was bound by that. There was never an amendment to the pleadings. Again, just by reading the answer and counterclaim along with the complaint, it's clear that that was admitted. In addition, I would point out, this is technically not relevant, I guess, but Mr. Copeland actually filed a counterclaim. The counterclaim identifies him as a countercomplainant. And his claim is that he's due money under this arrangement. Again, he labels it as unjust enrichment and money had been received. The court determined that it was really just a breach of contract claim based on the same contract that Old Hickory sued under. And he affirmatively alleged that the parties entered into a contract and asked the court to give him a judgment for, again, essentially breach of that contract. So at this point, he's clearly a party. He's admitted to being party to the contract. If Star Coach breached the contract, Mr. Copeland breached the contract, he's liable to the same extent as Star Coach. Now, Star Coach has filed a cross appeal. Yeah, go ahead.
Mr. Knight, I have a question for you. At the time of trial, were you in any way restricted in your proof that you put on as to your claim against Mr. Copeland? Were you allowed to put on all the proof that you had prepared?
Your Honor, I can't think of any. Certainly, there's nothing that we've complained about on appeal. I can't. I think that we were limited to some degree, but honestly, I can't recall what it was. I don't think it related to the terms of the contract or anything like that.
Well, at the conclusion of your case, yes, did the court not find that there was no proof of personal liability on the part of Mr. Copeland? Did the court not make that? The
court did, Your Honor, and so in the pretrial brief, the Star Coach argued corporate veil. They haven't pierced the corporate veil. And our response was, we never alleged piercing the corporate veil. We alleged that Mr. Copeland was a party to the contract. There's no need to pierce the corporate veil. That's irrelevant. That's not an issue. Of course, we didn't offer any proof on that. Our position is he admitted in the answer that he was a party to the complaint. There's no need to put on any evidence piercing the corporate veil or anything else. That's the equivalent of a stipulation. Just briefly on the cross appeal, the Star Coach.
Can I ask you to clarify that? Sure. Was his admission that he was a party to the complaint, or was his admission that he was individually a party to the contract?
Yeah, I think you only need to look at the complaint to see whether he was a defendant. The answer and counterclaim is consistent with the fact that he recognized that, but I don't think it really matters what's in the answer and counterclaim as far as whether he's a defendant. The admission relates to whether he was a party to the contract.
Right. In other words, it does. What was that admission? Not that he was a party to the complaint, but whether he was a party to the contract.
Right. So paragraph 18 of the complaint said the first agreement was a valid and enforceable contract between Old Hickory, Copeland, and Star Coach. And he admitted that in his answer, that he was party to a valid contract between those three parties, including Star Coach and Copeland. All right. The only thing I was going to say about the issues raised on the cross appeal, two things. One is for Star Coach to get any of the relief it asks, it has to clear multiple hurdles on each of these issues. And secondly, all of the issues raised by Star Coach are there are very important findings of fact made by the trial court that are not attacked, that Star Coach has not asked this court to reverse. And so based on those findings of fact, there's no basis for granting the relief asked in the cross appeal.
Thank you, Mr. Knight. Are there any questions from the panel? Okay, hearing none, Mr. Griffin, we'll hear from you.
Thank you, Judge McBrayer. Excuse me. May it please the court, my name is Davis Griffin. I'm counsel for Applee Counter Appellant Star Coach Rentals Incorporated and Applee Mr. James Copeland. Before I go into the issues, I know that the court has read the briefs and has heard from Mr. Knight. Is any factual background further than what's been mentioned necessary or helpful before I go into the issues? Okay. Well, with respect to the issues on appeal, this court should make 4 findings. 1, this court should reverse the trial court's award to Old Hickory because Star did not breach the contract. Star gave Old Hickory all the notice Old Hickory was entitled to, and further, Old Hickory has no damages because it's been paid every dollar that it was owed. 2, this court should affirm the trial court's holding that Mr. Copeland only did business with Old Hickory through his company Star, which Old Hickory through its owner has actually asserted under oath. 3, this court should award Star damages for unjust enrichment because Star, taking on the extra expense of repairs and renovations to Old Hickory's equipment, brought that benefit to Old Hickory outside of any purported contract on the subject matter. And 4, finally, this court should award Star damages for the money had, money received claim pursuant to the line of cases from this court, citing Snyder versus Johnson, a Texas Court of Appeals case, because Star inadvertently paid Old Hickory more than it was in fact owed. And Old Hickory does not even respond to this argument. First, Star did not breach the contract. Whether this is an enforceable contract or not, the trial court found that the terms of the agreement were 1, Old Hickory was to provide equipment. 2, Star Coach would lease that equipment to production companies in New York. 3, Old Hickory and Star would evenly split the rental income of the equipment 50-50. 4, Star Coach was responsible for routine maintenance. And 5, Old Hickory was responsible for other things other than routine maintenance, which was defined as significant repairs and renovations to the equipment. Now, the trial court held that pursuant to McLean versus Kimbrough Construction Company, Star had breached its duty to provide notice to Old Hickory that Old Hickory would not be getting rental income for equipment Old Hickory did not provide. Well, first, the purported contract between Old Hickory and Star contained no notice requirement, but this court in McLean held that, quote, notice ought to be given when information material to the performance of a contract is within the peculiar knowledge of only one of the contracting parties. And in the absence of an express notice provision, the courts will frequently imply an obligation to give notice as a matter of common equity and fairness, end quote. Well, Star fully complied with that obligation. The only material information in the peculiar knowledge of Star shared with Old Hickory, and that was these requirements from NBC for Star to renew the lease in 2008. The trial court found that upon learning this material information, which was that the Star would have to get bigger new trailers and bigger trucks to pull those trailers, the trial court found that Star picked up the phone and called Old Hickory, informed them of that requirement, and the trial court further found that Old Hickory informed Star at that time it could only afford the new trailers, not bigger trucks. That Old Hickory would not be entitled to rental income for equipment it did not provide was not peculiar knowledge to Star. Old Hickory knew that because it was a basic term of the contract. Star was under no obligation to reiterate that to Old Hickory. Accordingly, the trial court erred in holding that Star had breached the contract by failing to give notice. But even if Star did somehow fail to provide notice, Old Hickory has no damages. Full payment negates Old Hickory's prima facie case for breach of contract. This court, in a case in 2016 called Smith versus High Speed Incorporated, held that very thing. This is where a trial court had issued a final judgment in favor of a defendant on the plaintiff's breach of contract claim after finding the defendant in that case had made every payment that it needed to make under a commercial lease agreement in the years at issue in that case. And this court held that because the payment of all of those monthly rental obligations for all those years had been made, as the record in that case demonstrated. The trial court held that here, because Star had breached the contract by failing to give notice, that Star was, quote, responsible for paying Old Hickory 50% of the rental income for each unit, not just the trailers, end quote. This holding is an error. A unit is just an industry term for a truck and a trailer together. What the record shows is that Star negotiated the price of and billed NBC separately for trucks versus trailers. There was no unit price. Again, Old Hickory was to provide equipment for Star to lease and split the income from, not units. That's what the trial court actually found. Moreover, Old Hickory has admitted it did not provide trucks when it was asked by Star to do so around 2008. And Old Hickory continued to receive payments for its trailers all the way up until until Star wound its business up in 2015. Per the agreement, Old Hickory was only entitled to rental income from equipment it provided. Old Hickory received all the rental income for equipment that it provided. In fact, it received more than its share. Proof that Old Hickory was paid at least 50% of the rental income for equipment they provided is found in two sets of exhibits at trial. The first set is 22 through 34, which is Star's 1099s for Old Hickory from 2009 to 2015, cross-referenced with the second set of exhibits, which is Star's invoices to NBC for those same years. You can see what Star charged NBC for truck and trailer, not unit, and then you can see what week after week, month after month, year after year, Old Hickory received per trailer, per week, which was even $750. Now, that's more than 50%, but I'm going to get to those overpayments in a minute. The point is that those two sets of exhibits are what Smith versus High Speed Incorporated say is proof of full payment, which negates their breach of contract prima facie case. The second issue I want to address is whether Mr. Copeland was, the fact that Mr. Copeland was never a party to this purported contract. Now, Old Hickory claims that the allegations in its complaint were designed to put Mr. Copeland on notice, that Old Hickory considered him a third party to its purported contract with Star, such that he could, of course, admit such a thing. However, the allegations filed immediately after the complaint, and importantly before Star and Mr. Copeland answered, make clear that Old Hickory did not intend for its allegations in the complaint to purport any such thing. Old Hickory owner Sherry Wise filed a sworn declaration in support of her response in opposition to our motion to dismiss, which is in the record at volume 1, page 119, which contains the following sworn statements of fact. Quote, "We agreed that Old Hickory would supply Star Coach with 6 two-room cast trailers, 6 Chevy trucks, 2 Winnebagos, and a camera truck. Star Coach was to then sublease the vehicles to various production companies in New York. Over the years, Copeland contacted me on various occasions to request that I purchase additional vehicles for Star Coach to lease or arrange for certain upgrades to existing vehicles," close quote. Now, these are just two of over a dozen sworn statements in that declaration where Wise makes crystal clear that Old Hickory did business with Star and not Mr. Copeland. There's no collective reference or non-obvious definition of Star Coach in Wise's declaration. Star Coach means Star Coach Reynolds Incorporated, not Mr. Copeland. These statements of fact by Old Hickory's owner clearly show who Old Hickory thought it did business with all those years, and that is, of course, Star. Now, Mr. Knight discussed, and Old Hickory cites this Bill Walker and Associates case for the proposition that an individual can be a party to a contract in addition to that individual's company. Well, whether such is possible is not the question before the court. The question before this court is whether Mr. Copeland was in this case. The answer is clearly no, as shown by the owner of Old Hickory's sworn statements that we just went through. But moreover, Bill Walker and Associates is an opposite to this case that involved a written contract with the defendant's individual name and a DBA next to it, doing business as his company on the signature line, which he signed. And expressly in the language of that contract was that individual agreed to corporately and personally take on the obligations of that contract. That is not what we have here. Accordingly, this court should affirm the trial court's holding with respect to Mr. Copeland's status. Moving to Starr's claims, first for unjust enrichment. Old Hickory was in fact unjustly enriched by Starr's performing repairs and renovations to Old Hickory's equipment over the years at Starr's expense. And that is reflected in the trial court's finding of Old Hickory's indebtedness, albeit under the breach of contract theory, which Starr did not advance because we maintain that there was no enforceable contract. And so it's equitable relief that we had asserted, and the indebtedness that the trial court found was just misplaced in terms of doctrine. The essential elements of an unjust enrichment claim are: 1, benefit conferred upon the defendant by the plaintiff; 2, appreciation by the defendant of such benefit; 3, acceptance of such benefit under the circumstances that would be inequitable for him to retain that benefit without payment of the value thereof. Now, courts ordinarily don't impose a quasi-contractual obligation when a valid enforceable contract exists between the parties on the same subject. But as Starr has argued at length, there is no valid enforceable contract on the subject matter because of the statute of frauds and the unavailability of any rescue from the partial performance doctrine. But even if this court affirms the trial court's finding of an enforceable contract, the subject matter of that purported contract does not cover what happened here, which is that Starr took on Old Hickory's obligation to bear the expenses of repairs and replacements to their equipment. The case of Markel versus Pollock Printing Incorporated is instructive here. In that case, a printing company had contracted Markel, who was a specialized serviceman, to, among other things, install a new sheeter on the printing press. After performance in the contract began, certain change orders were placed, and the decision was made to go with a later model sheeter, which Markel paid for and installed. Well, the contract had allocated $30,000 for the original sheeter, and the change order sheeter was far more expensive. So the trial court found, and this court affirmed, that Markel was entitled to the balance for the replacement sheeter under unjust enrichment theory, even though there was a contract. The same is true here. Old Hickory was responsible for paying for the repairs and replacements to its equipment. When it claimed it could not afford to do so, Starr had to. So Starr taking on that extra expense in order for the purpose of the contract or the agreement to continue to be served is just like Markel, for whom this court held, quote, under the principles of unjust enrichment, it would be inequitable for the defendant to reap the benefit of the upgraded sheeter without paying for it. Markel's claim for the sheeter satisfied the elements of unjust enrichment claim, close quote. Accordingly, this court should award Starr's unjust enrichment damages for those repairs and renovations of $12,415, regardless of whether this court finds that a contract existed. And finally, the money had, money received claim. Now, Old Hickory does not address Starr's argument for money had and money received at all. Old Hickory cites Bennett versus Visa USA Incorporated for the proposition that, quote, both unjust enrichment and money had, money received are essentially the same cause of action, close quote. While true, this language is just dicta in that case for a backdrop against which the court could discuss the concept of privity. The two claims actually have distinct standards, and I just outlined the elements of unjust enrichment a minute ago. It asks for money had, money received, quoting the 1953 case of Snyder versus Johnson from Texas. This court in 1995, in the case of Shelter Insurance Companies versus Hahn, held, quote, where a party to a settlement agreement mistakenly pays more than the amount agreed to, he is entitled to recover the overpayment amount, recover money had, money received, rather than unjust enrichment, close quote. This court has cited that Snyder case for that proposition, both in Shelter and again in 2000 in the opinion of Farmers and Merchants Bank versus Midway Supply Company. After Old Hickory refused to provide bigger trucks in 2008, Starr provided those trucks, but mistakenly continued to pay Old Hickory as if Old Hickory were providing the trucks for another couple of years. But even after correcting the payments in 2011, Starr inadvertently still paid Old Hickory more than its 50% share of the trailers. This map is laid out all in our brief, but Star's payment of even that flat $750 a week for that number of years, four-ish years to Old Hickory was more than precisely 50% of what NBC paid Star for those trailers. Until Old Hickory was sued by Star, this more nuanced overpayment, which is as compared with just trucks that were not being provided, it's a little bit more nuanced to look at what NBC billed or what NBC paid Star, and then look at what Star paid Old Hickory, and the difference in between that flat 750 and what actual half was is smaller, but over time it's just as consequential. These inadvertent payments to Old Hickory are recoverable in the same way that the payments in Snyder and Shelter and Farmers were recoverable. And for those reasons, Your Honors, Star and Mr. Copeland asked that this court reverse the trial court's award to Old Hickory for breach of contract damages, affirm the trial court's holdings with respect to Mr. Copeland's status in the lawsuit, and award Star unjust enrichment damages of $12,415 and money received damages of $17,439.08. Thank you.
Thank you, Mr. Griffin. Any other questions from the panel? Seeing none, Mr. Knight, will hear from you on rebuttal.
Thank you, Your Honor. I'm going to start out by addressing a couple of the factual, of course, I welcome any questions from the panel, but a couple of the factual findings and evidence in the case that Mr. Griffin addressed. One of which is he said that Mr. Copeland, and this has to do with the issue about supplying the trucks. He said that Mr. Copeland informed Ms. Wise that a requirement of the contract was 2 new trucks, and she said, I can't afford to buy 2 new trucks. The court's findings, it's on page 770 of the record in the memorandum in order in volume 6. There's a paragraph, the whole full paragraph there is where the court takes the contrasting testimony and makes its findings about what the court thinks actually happened. And what the court says about that is that Mr. Copeland asked Ms. Wise about new trucks. Not, he said there was a requirement, we're not going to have a contract. If Ms. Wise had thought there was no contract without her buying new trucks, she wouldn't have gone to Missouri with Mr. Copeland to the manufacturer to look at trucks, sent information about the trucks to NBC for their approval, and bought two brand new cast trailers. But the court says that Mr. Copeland asked about new trucks, and Ms. Wise stated that she could not afford them at the time. Now, that is not an indication that this contract was going to be canceled if Old Hickory coaches didn't buy 2 new trucks. This contract was performed. This was in 2008. These cast trailers were leased out under this agreement for 7 years after that. And according to the court, during those 7 years, Mr. Copeland never came back to Sherry Wise and said, can you afford the new trucks now? You know, you said I can't afford them at this time. How about getting me some new trucks? And I think the reason is that Mr. Copeland had a thriving business long before Old Hickory showed up in 2000. He had his own trucks, he had trailers, and most likely he didn't need Old Hickory to provide pickup trucks. He had sufficient pickup trucks to move the trailers and do what was necessary. And so he didn't ask more than that once. He asked about new trucks. That's what the court found. In addition, this idea that there was no negotiation of a unit price for the cast trailers, for the industry term unit. I don't think that's supported by the record. There's certainly no finding. In fact, the court's finding was that it was consistent with the parties' agreement that Old Hickory be paid half of the unit rental for supplying the cast trailers. The only purchase order in the record, because it's the only one produced by Mr. Copeland, is a purchase order for 2 trailers. It includes information about that parking, storage is included. Doesn't say anything about pickup trucks. It's a purchase order for 2 trailers. I'm sure NBC expected pickup trucks to be provided, but the purchase order was for the trailers, and the negotiated price was for units, which primarily meant cast trailers. The invoices, Mr. Copeland unilaterally decided what to put on the invoices. And the record contains invoices showing charges for trucks anywhere from $1,000 a week to $0 a week. It was just totally arbitrary what Mr. Copeland decided to put on the invoices. As long as the total added up to the negotiated unit price, the customer didn't care about that. I want to go back briefly again, unless there's any questions, to this issue about piercing the corporate veil, the evidence presented at trial, because this is where I think the trial court initially made the mistake. By Star Coach argued in its pretrial brief that that Old Hickory could not pierce the corporate veil. It raised that as a defense, by the way, indicating that it thought he was an individual defendant. Otherwise, that would be totally irrelevant. The court determined that that had not been proven at trial. And there's a reason for that. Mr. Copeland admitted in the answer that he was a party to the complaint. Old Hickory didn't take discovery on the corporate veil issue because there's no reason to. Mr. Copeland admitted he was a party to the complaint, and that was the basis of our motion to alter or amend was, Judge, we agree. There wasn't evidence of allowing the court to pierce the corporate veil. There was no need for evidence. He admitted, paragraph 18, among others, that he was a party to the contract. So we've just asked the court to reverse the judgment in favor of Mr. Copeland, remand the case for entry of judgment on breach of contract against Mr. Copeland to the same extent as the judgment against Star Coach.
Thank you, Mr. Knight. The case is submitted. We appreciate arguments from counsel for both parties. Ms. Lindsay.
This Honorable Court of Appeals stands adjourned.
Thank you.
Thanks again, gentlemen. You can disengage.